Yeah, so we are going to start a new topic. Okay, you will find this in your module 2, and it's a very interesting topic in thought, but very complicated though, because even judges, as you will see, struggle. They agree, they disagree on situations, cases when negligence has happened, leading to giving rise to a cause of action, and also claim for damages. Okay, so this is a very interesting topic, but complicated nonetheless. So I'm not saying that in our class discussions you will be very clear with the topic, but no, that's not going to happen because it's a lifelong process, and as you study, as you learn more, you will have clarity. But our classrooms, classroom discussions will definitely give you some clarity, some direction as to what this topic is all about. Negligence, okay, as we understand, is basically the idea that okay, so you had some responsibility, okay, some duty you had, okay, and you were supposed to take certain apply certain level of diligence, certain level of skill, or certain level of care, okay, uh, but you didn't, okay, okay, you were not being responsible in a very lay sense. Okay, if you were to ask someone, okay, what do you understand by negligence? Well, you didn't do something the way you were supposed to. You were being careless, you were being reckless, you didn't pay heed, all these things we say. Okay, so you had certain expectations of someone, that that someone will do something, exercising certain kind of uh, care, certain kind of responsibility. That person didn't do that, and as a result certain consequences happened. Okay, so in simple words, okay, uh, the legal understanding of it also is not too different, but then when you come across specific cases, I mean, you will see that well, it's very difficult to define. Okay, so anyway, let's start. Okay, what it means. Okay, so negligence has been defined like this. Okay, I will read out certain quotes here. It says, negligence is a breach of a duty caused by the omission to do something. Okay, so it says negligence, okay, is a breach of a duty. So as I said earlier, I used the lay term, okay, responsibility. You had some responsibility, you had some duty. So it assumes that there is a duty that exists. Okay, now the question is, duty under what? Is it statutory duty? Well, there could be statutory duties as well, okay, but then it's not restricted to statute. Okay, it could be other common law duties as well. Okay, so and then within the common law there are certain principles which are accepted. Okay, so based on those principles as well, certain duties might be imposed on you. So it need not ensue only from statutes. Okay, and if the statute lays down certain duties, your duties do not get exhausted by those duties which have been laid by the statutes. Okay, you could also have other duties under the common law and the principles under the common law. Okay, so it's a very open-ended idea. Some of you have also had presented on the question of presence of morality and tort. You will see how interwoven these ideas are, at least in these cases. Okay, so it said that there is a breach of duty. Okay, so you had a duty and you breached that duty. Breach means you didn't fulfill the duty. Okay, you broke the duty. Okay, you breached the duty. Caused, how did you do it? Caused by omission. So you had a duty to do something, you didn't do. Okay, do something which a reasonable man, okay, now this is a bit of patriarchy, okay, as you will see. It says reasonable man. So yeah, so it's from an old judgment from 1856. Okay, the standard of reasonableness back then was reasonableness of men. So let's understand in today's context it to be something which a reasonable person, guided by those considerations. Okay, guided by those considerations. Okay, which considerations? Okay, it says which ordinarily, not extraordinarily, okay, which ordinarily regulate the conduct of human affairs, okay. This is what you are expected to do in the regular human, affairs, okay. You need not show extraordinary care, okay, extraordinary skill. You do not have to be Superman, Batman, to be able to fulfill this duty, okay. So it says, which ordinarily regulate the conduct of human affairs, would do or doing something, that was omission, and the other one is, or you do something which prudent and reasonable man, we will read it as person, would not do, okay. So you omit to do something which a reasonable person would do, or you do something which a reasonable and prudent person would not do. Now the difficulty arises with respect to defining what is reasonable, okay. The idea which seems to be very easy, it's not that easy to understand. However, we should not, because of that, say that it is not possible for us to understand what is expected of reasonable, person, okay. So what is expected of you? As I said, it is ordinary care and skill. What I would say, what is it? Does it refer to ordinary? What does ordinary care or skill mean? Does it mean average care or skill that people of a community show? No, it need not be that, because people of a particular place might be, you might find that well they're not really that diligent, okay. So what is this ordinary care and skill? So it's like what you would expect from a reasonable person, okay, person who's subject to reason, okay. This is what is expected of you. Now you see, this can not be defined, right here, right now, for you to forever be guided by, that principle. So this is something which the judges will decide in specific cases as to what was the reasonable care and what was the reasonable skill that was expected. Now this will vary though. If you sought help from some expert, okay, someone who's an expert in the field, now the expectation that you have from that of expert would not be of an ordinary person on the street. No, it will be what is reasonably expected from an expert, okay. The care and skill that you would expect from an expert, but only if you have sought some help from the expert, okay. In that situation I'm talking about. Now I hope this is clear, okay. Is this idea clear so far, the introductory?
Sorry, little doubt.
Yes, tell me.
I mean, if there was a road accident and a doctor by chance goes to help an individual, he would be
slow down a little bit because of network connectivity. Yes, tell me.
Yeah, so if like an accident happened on a road, and a doctor goes to help the individual, he will be subject to ordinary care, right? Not the expert doctor level of care.
Yeah, so it depends on what doctor is it, okay. So what kind of care is expected in this situation, okay. So if this guy is an ordinary doctor and MBBS, you wouldn't expect from that person the kind of care that you would expect from a surgeon, okay. Nor would this person be authorized to do anything that surgeon would do. But you would expect from the doctor the same care that you would expect from any other doctor of that standard. I hope you understand.
So he's expected to take the care that a doctor would take.
Yes, that's the idea. That's the idea. Now suppose see, this doctor here, okay, I mean, we are still not talking about medical negligence, okay, so we are not yet at that stage, okay. So suppose a victim of an accident has been brought to hospital, what kind of care that the doctor has to show. So we have an entire test laid down regarding that, so we would be ahead of our time, okay. If we talk about that, I'll address that question when we come to medical negligence. But for now, let me tell you this, that your expectation from the doctor would be what you would expect from a doctor, not from an ordinary person. Got the idea? However, if the doctor is of certain caliber, then you wouldn't expect from that doctor some care that you will get from a super specialist for that matter. But then this doctor will not do something that the super specialist will be authorized to do. Do you understand? So obviously that person should also not do what he or she is not authorized to do. Got the idea?
Yes, sir. Yes.
So we will deal with this question of negligence, medical negligence, later on. As we take up that topic. So I hope this is clear. So idea is that if it is ordinary person, okay, lay person, okay, who you did not seek any spatial, expecting a spatial, skill from, then obviously in such case it will be, what you would ordinarily seek from, such person, the ordinary care and skill. But if it was from someone, holding a particular position, and then is required to show certain kind of skill, and that will be the standard that will determine what will be the ordinary care and skill that you would expect from that person. So the thing is that there might be contractual, expectation that's there apart from the contract as well. Under the law, okay, under the law itself, you might have certain other expectations. We'll take up those cases in a while, don't worry. So yes, there are many other ways of defining it as well. Okay, so for example, according to Winfield, okay, the book that I had referred to earlier, okay, Winfield says negligence. Winfield defines negligence as a tort is the breach of a legal duty to take care. So there is a legal duty to take care, okay, and that duty has been breached, okay, on the part of the party complained of, okay, take care, which results in damage. Okay, I'm sorry, misread here, skipped a sentence here. Okay, so Winfield says negligence is a tort. Okay, negligence as a tort is the breach of legal duty to take care, which results in damage undesired by the defendant, okay, to the plaintiff. Okay, so the thing is that, one important element that you might notice which has been showed here is that the defendant did not intend to cause that damage to the plaintiff, but because of not showing, the expected level of care or, skill, it had happened. Okay, not that the defendant had done it deliberately. Okay, so not that. Okay, so that's a very important element here that we need to look at. So essentially there are three elements which are identified with respect to this tort, that is tort of negligence. Okay, there are three elements that you need to remember. Okay, so the first is the presence of a legal duty. Okay, there has to be a legal duty. So it could be under the precedent laws as well. Okay, so this is hello. Go. Hi. 20 তারিখ সানডে নাকি? বসুন এক সেকেন্ড মই চাই লওঁ। অ' 21-ৰ পৰা 23 কৰি দিব লাগিছিল এইটো, নহয়? কি আছে এইটো কওকচোন? 21-ৰ পৰা 23 হ'ব। এইটো মোৰ ভুল হৈছে। আপুনি কৈ দিব পাৰিব না তাক? হাতেদি কৰি, মোৰ চিগনেচাৰ আছে, চিন্তা কৰিব নালাগে। হয়, এইটো অপৰাজিতা মেম। হয়, একো নহয়, মোৰেতো, মই মানে কমপ্লেইন নকৰোঁ এইটো। ঠিক আছে, 21-23, হয়। Sorry guys. So there are three elements. I always get calls during my classes. So there are three elements that you see in case of negligence. The first is that there has to be a legal duty. Okay, the presence of a legal duty. So legal duty, what duty is it? Okay, so that is the duty to exercise due care. Okay, what is a care that is due? That is what the judges will find out in different cases. Okay, but when I say judges will find out in different cases, it's not as if judges are creating the duties in those specific cases. Okay, now with respect to this, we have two different jurisprudential positions. Okay, one that says that judges in fact in those specific cases create new duties based on their policy considerations. The other one that says that no, judges cannot create new duties, then you will be made liable for something which was not liable, which you should not be made liable for, because you did not already have the duty of care. So we have these two different, opposing point of view. But let me not confuse you with all that as of now. Just remember, it says that there is a legal duty to exercise due care. Okay, you had a legal duty to exercise due care. Okay, on the part of who? Okay, on the part of the party complained of, that is the defendant, okay, towards the party complaining, that is the plaintiff, okay, complaining the defendant's conduct here within the scope of the duty. So there is a legal duty, okay, to exercise due care, okay, due care is to be exercised, okay, by the defendant, okay, complained of by the plaintiff, okay. So that's the first element, the presence of a legal duty to exercise due care, okay. Well, mere presence is not sufficient. Something has to happen with respect to that duty. So the next element is breach of the said duty, okay. The defendant has breached the said duty. So either through omission or through commission, okay, that duty has been breached, okay. Omission when there was a duty to do something, and commission when there was a duty not to do something, okay. So by virtue of that, a duty has been breached, okay. Now mere violation of breach of duty is not sufficient, okay. Along with that, there is a third element, and that is that there has to be damage, okay. There has to be consequential damage. Now here, understand this, consequential damage is understood differently in different contexts, okay. So in this context, what it is that, okay, it is the damage that you have suffered as a consequence of breach of the duty, okay, the damage that you have suffered as a consequence of breach of that duty. Now there could be many different kinds of damages, okay. Now would every damage come under this? We will study that in our discussions subsequently. Now the damage here which has been suffered is essential, okay. Now even if someone has been negligent in doing something, okay, if that did not lead to the plaintiff suffering any consequential damage, then there is no cause of action here, okay. So you will not have any remedy essentially, okay. So that's essentially the point, okay. Now you know that there is law of limitation, okay, that lays down, okay, the period of time within which you are to institute a suit with respect to a particular cause of action, okay. Now in tort, it is essential, okay, especially in this case also it is essential, okay. Why is it essential? So for example, a period of limitation of 2 years or 3 years, whatever is laid down under the Limitation Act, okay. So we have to calculate when in the law of limitation the period of limitation starts, okay. So that we need to do, okay. Now the thing is that sometimes what might happen is that someone had been negligent, okay. So by that I would say that that person had a duty of care, that person breached that duty, and as a consequence, okay, you have suffered damage, okay. But when damage occurs, okay, before the victim actually knows the damage has been suffered, what about that, okay. So damage has already happened, okay, but the victim didn't actually realize that, well, damage has been suffered due to the negligence of the person, that is the defendant, okay. So the incident happens suppose today, okay, and then you as the plaintiff come to know of it after a week or a month later, okay. So will the period of limitation start running from the day when it has happened, or from the day when you have come to know of this, that the damage had happened because of the negligent act on the part of the defendant? So can you answer what the right answer
I
will be?
guess it's from the time of the commission of the tort.
From the time of the commission of the tort? What if it was not within your capacity to discover? You found it only later, so why should you suffer in that situation?
So I'm not sure, but during my project only I read somewhere about the limitation project. In that case, there was a aspect of limitation period as well. It was written that the limitation period starts from the commission of the tort. At least in that case, the judgment held that it started from the commission.
See, law of limitation is very strict about it, that yes, law of limitation is to be followed, okay. But in this particular case, okay, yes, usually it will run from the time that cause of action had arisen, okay. But if you had no way of finding out, okay, that yes, I have suffered this because of the negligence of the other, in such case, the law takes the next course, that well, when you came to know, okay, that yes, the this damage which I have suffered is due to the negligence on the part of the other person, and that had led to it, the limitation period runs from then, okay, that when you come to know of this, that yes, you have suffered it due to the breach of duty on the part of the other. Okay, so you have to be able to make that link, don't you? Although as you will see, what I'm saying is a particular principle, a particular position, but law of limitation itself lays down in great detail when it will start. Okay, so you will always keep in mind what the law of limitation and the articles which lay down when the period of limitation starts, you will follow that. But in this situation, it starts when you come to know that yes, the harm that you have suffered, the damage that you have suffered, okay, by the plaintiff here, had been in fact because of the negligence on the part of the other. Okay, otherwise when it starts, it is laid down in the law of limitation itself. There it is laid down exactly when it starts. Okay, so if it says that it starts from the day when someone comes to know, or from the day the cause of action, the judges will go accordingly, and discretion shall not be applied by the judges in those cases. Okay, so strict interpretation is applied in case of law when the law of limitation lays it down clearly. But in this situation, this is generally the idea. Otherwise, why would we impose that disadvantage upon the plaintiff? Is that okay?
Yes, sir.
Okay, so along with this, the damage has to be real. Okay, the damage has to be real. Okay. Now, why is this important? Okay, if you remember the doctrine damnum sine injuria, okay, and there you remember the violation of a legal right in itself is leads to cause of action. Okay, so injuria sine damnum. Okay, that violation of a legal right in itself leads to a cause of action, and you are entitled to damages then. Okay, but here in this particular case, in the case of negligence, the important requirement is that real damage has to be there. Okay, just because someone has been negligent in itself is not cause enough for you to seek damages. Okay, there has to be real damages that happens. Along with that, negligence, as I said, okay, when I was trying to define the idea of negligence earlier, I said that negligence, if you were to ask a common person, lay person, what will they say? They will say that, well, someone was being careless, okay, someone did not pay enough attention, someone was being heedless, okay. Well, we cannot equate negligence with, any other heedlessness or carelessness, okay. This is like what is expected of you under the law, okay, and you have breached that, and as a consequence someone has to suffer some damages. Okay, so that's how the idea of negligence, in the idea of negligence, the presence of damages is very important. Otherwise, someone being careless, heedless in itself is not reason enough to lead to a cause of action. One more thing that we need to distinguish is between negligence which is civil in nature and the negligence which is criminal in nature. Okay, now this is a very important distinction that we need to make. So what are the important elements that distinguish? One is definitely the degree of negligence. Okay, that definitely matters. Okay, in criminal negligence, the degree of negligence, okay, has to be higher. Okay, it could also be gross negligence, okay, complete negligence. There was no reasonable care, okay, care exercised at all. Okay, so if it is so gross, then it has fulfilled one of the requirements. Okay, the other requirement is the presence of mens rea. Okay, you also have guilty mind there. Okay, guilty mind there, that you intended to do something. Okay, so that's what distinguishes between criminal negligence and, on the other hand, civil negligence. Now, I'm not saying that in a criminal act that constitutes a criminal negligence, you cannot take the person to also a court to seek compensation. No, if you remember, the same set of facts could also lead to both civil as well as criminal negligence. Okay, but then for it to constitute criminal negligence, the degree of negligence which is shown here, okay, must be higher, okay, then you would expect, then what is required in a civil negligence, okay, or it is a gross negligence, that there was absolute lack of any regard whatsoever, okay, towards the duty that the defendant had. Along with that, mens rea must be present. Then you have what we understand as criminal negligence, and this is what was held in the case of Jacob Matthew in 2005. So I hope we are clear so far.
Yes, sir.
Okay.
Yes.
Huh? So yes, yes. Vishwajit, you have a question?
Yes, sir. Sir, I have to know that, sir, if negligence can be a zero, even in the case of if we are serving zero, like if we are giving a food in free, in this case, can be a negligence be a zero? Is duty of care?
No, duty of care is always there. If you are distributing food for free to someone, okay, does not mean that you wouldn't ensure that the food is not, food is edible, okay. You give someone, okay, something to eat, and that causes that person some serious, ailment. So that is what is expected of you. So whether you have duty of care or not, that's the question that we need to look at. If you were a judge, how would you decide? Do you not have a duty of care towards your neighbors? By neighbors, I'm not talking about your neighbor, your neighbors of your house. No, not just that. Anyone around you is considered as neighbors. So negligence is also known as law of neighbors. Okay. So don't you owe a duty of care then, even when you are giving food for free?
Okay, sir. Thank you.
You have the duty of care, don't you? Okay, so existence of duty. Okay, so as I said, the duty, you may not find it anywhere in a statute that says that, well, if A is going to distribute food for free, then this is the duty that A has. No, that's not what we are talking about, that it has to be exhaustively laid down in a particular statute. Even in countries where the law of tort, for example, is codified, for example in France, they I think have only 5 sections in their entire French civil code that deals with law of delete, okay, which we know as tort. Okay, now as you know, those 5 sections will not be sufficient to deal with all the cases that come before the judges. Okay, so the law itself leaves a lot of discretion for judges to find out whether a person has a duty or not. And quite often you will find that it is there in the legal system. Even if you're not able to trace it from a particular statute, you will be able to trace it from either precedents or certain principles which are taken for given in that particular political community. And this is the thesis which has been laid down by one of the jurists by the name Ronald Dworkin. We'll discuss that later on. But as you can see, the duty of care exists. Okay, you owe a duty of care towards your neighbors. Okay, by that I'm using the word neighbor generally. Okay, so there is an existence of duty of care. Okay, but how does the duty of care exist? Okay, where does it come from? Okay, so yeah, you will find, as I said, you will find it based on certain existing precedents. Okay, you might find it in a particular previous judgments. You will find it there. Okay, even if it is not laid down clearly that, well, in this specific case, okay, this is exactly what the duty of care is. Even if you don't find something like that, the broad principle will nonetheless be there. We will look at one, okay, in an example that we are going to take very soon. Okay, so you might find it in the precedents. Okay, now the question is that sometimes before the judges, a completely new situation arises, the answer to which the judges are not able to find based on the existing precedents. Okay, what do the judges do there? Okay, do they recognize new duties there? Now that's a very problematic statement, because if the judge is recognizing a new duty, then the person who might be blamed for breach of duty will be blamed for something that did not exist. Okay, so you breached a duty that already did not exist. Okay, so this is a very important philosophical as well as relevant problem for us. Okay, so what about a new duty? Okay, so we could say that yes, new duty is not recognized, but a new situation is applied. Okay, new situation comes before the court where a duty which already exists is also recognized. Okay, so it's not as if a new duty is recognized after the act has happened. Okay, after the act has happened. Okay, it's just that it's a new situation, but based on some previous principles, okay, that already exist, we can say that you had a duty of care even in this new situation. So I hope I was able to make sense. Did I make any sense?
Yes, sir.
Huh? We'll discuss in certain case laws that
Yes,
we'll
sir.
take up. Okay.
Could you explain the limitation period bit again?
Yes, I'll come to that. Can I complete this portion?
Sure.
Okay, just this portion, and before I go to before I go to the case laws, I'll explain that. Okay, so you have a new situation might arise where judges recognize a duty. Okay, but the duty is not judge's own creation. Okay, that's one of the jurisprudential position. Okay, it's a duty which is already there. Okay, you will find it in the principles that exist in that particular legal system. Okay, whereas there are others who say that the duties are recognized based on judge's own policy consideration. We'll look at this debate subsequently. Another thing is that there are two other principles based on which a new duty situation might be recognized. Okay, those are foreseeability. Okay, whether you are able to foresee that, well, this is what will happen if I do this. Okay, this is what will happen if I do this. So you foresee that. Okay, is it foreseeable for you? Can you, when you did something, was it can we assume that a reasonable person would foresee that, well, this will be the consequence? Okay, that's one. The other one is the proximity. How close? Okay, proximity is not physical proximity we are talking about. I mean, one cause, one event leads to another. Okay, how close are they? Are they intervened by many different events? Then the distance between the two events far. Okay, even though they might be physically close, but if there has been many other events that intervened, okay, then we don't say that they are proximate. So it will be like one event happened that led to another. Now that proximity, again, as I told you, is not physical proximity. Okay, so yes, that's the idea. Okay, so in new duty situation, these are certain things that the judges keep in mind to decide whether there is a duty of care or not. Okay, now coming back to this question that our friend is asking here. Okay, that what happens is that so suppose someone is being negligent. Okay, someone had a duty of care. Okay, that he or she is expected to exercise. Okay, show reasonable care and skill, whatever. Okay, and that person didn't show that, and as a consequence someone has suffered a damage. Okay, but you do not notice that that damage. Okay, you notice that damage subsequently and then realize that that damage has been suffered because of negligence on the part of the party. Okay, now the question is, in such case, when should the law of limitation start? Okay, from the moment that the negligence has happened, or from the moment that you have come to know that you have suffered it because of negligence on the part of the other person. Okay, so what I had said was that usually when the law when the limitation starts. Okay, let me find out here. I will show you some examples. Okay. So when the limitation period starts, okay, will be determined by the specific articles which are there in the Limitation Act. Let me share the link with you guys. We have broadband here, still it's very slow. So you can easily get it here. Okay, so you will see here the act. Okay, the top part is just a second. No, it's just a second. You don't have the schedule. I mean, and the articles here. I'll send you another link, the Law Commission of India link. I think if you Google, you will find it. Okay, let's look at some of the provisions where the limitation period is laid down. So another link I'll share right now. Just a second. Click on the second link. You will come across the articles here as well. Okay. Oh no, sorry. This is I think Law Commission. Just a second. Let me find it. This is not. Just a second. This is the Law Commission report. Sorry. The internet is very slow at my end. So you will see that there's one link. Okay, if it's there. I need one whole PDF. Then it makes it easier for us. Sorry. You can click on this one. Maybe this will be of help. Okay, so here, as you can see that how computation is done and everything is laid down here. Okay, in part 3, as you can see, it lays down how it is to be done. Okay, computation is to be done, and then you see in the schedule which is attached. Okay, you will see specific description of the suit and period of limitation. Okay, that exists. Okay, so let's take a look at one. Okay, suits relating to tort. Okay, so here you will see everything is laid down here to a great extent. Okay, can you see it? You see that in part 7, you will see in Limitation Act 1963, the latest link that I shared, it is laid down. Okay, so you will have to follow this. Okay, this is the limitation, and this is how it flows. So for compensation for during or omitting to act alleged to be in pursuance of enactment in force. Okay, let's look at the other ones. Okay, for compensation for false imprisonment, 1 year when the imprisonment ends. Okay, it cannot be when it begins. Okay, so it has tried to rationalize as much as possible. Let's look at where negligence is here. So as you can see, it does not say anything specifically about negligence, because it's a very broad category. But with respect to others, you see it has been laid down. So for example, for compensation for libel, 1 year when the libel is published. For compensation of slander, 1 year when the words are spoken. Okay, so you will see that as it has been laid down here. Okay, it will be strictly adhered to. Okay, because law of limitation has this, that it is to be strictly interpreted. Okay, so no discretion is to be exercised by the judges. But in other situations in which the judges are judges do have the discretion, for example in the example that we just took up. Okay, in this situation, if the plaintiff couldn't have known, okay, at the moment that the damage has been suffered by the plaintiff due to the act of the defendant, then it seems not proper to say that, well, the limitation has started when the negligent act had led to the harm. Okay, so we can say that, well, a person can be expected to institute a suit when that person comes to know that, well, I have suffered because of the negligence on the part of defendant. Okay, that's why the law of limitation, the limitation period in such situation should flow from.
Sir?
Yes.
Sir, sorry to interrupt you, but we have a test of blockchain technology right now. So can some of us?
Oh, I'm sorry. I forgot. So yeah. So we'll do one thing. We'll carry on in the next class. Okay.
Yes, sir. Thank you.
Okay. Take care.
Excuse me, sir.
Yes.
Thank you.
Sir, I am present, so can you mark UID 63?
Just a second. Do one thing. You type your here roll numbers here in the box.
Sir, so should I tell you my doubt right now or in the next class only?
If you don't have any class, you can tell me now. No problem.
Sir, I don't. So my doubt was that the case which I took up for my assignment, which was Jai Lakshmi versus State of Gujarat.
Yes.
That Justice B.J. Diwan, it was also a case of negligence only, but on the part of the state. In that Justice
Aditya, do you also have a class now?
No, sir, I don't.
No, then just wait. Let me take all the attendances. Okay.
Sure, sir.
And I'll be around. Don't worry. Okay, how many students missed? Okay, there are lots of students who missed. Okay, so don't type, just tell me quickly because I'll again have... Oh, sorry, I didn't even take your attendance at all.
UID 63.
Yeah. If you guys haven't left, can I quickly take your attendance?
Sure, sir.
Okay, just 1, 2, 3, 4.
Present, sir.
4 is there. 5, 6.
Sir, no 5. Present, sir.
6, 7, 8.
Yes, sir.
9, 10,
Present, sir.
11. Okay, 11 is not there. 12. Verse was there.
Present, sir.
13, 14, 15, 16, 17.
Present, sir.
16 or 17? 16.
Sir, 16.
16, 17.
Sir, 15 present.
Respond quickly. Yes. 17, 18, 19, 20, 21, 22,
21 present.
22, 23, 24,
Present, sir.
25,
Present, sir.
28,
Present, sir.
29, 30, 31, 32, 33.
Present, sir.
Go, I'll give attendance to everyone. It's okay. You will be late for your class. Don't worry. You'll get your attendance. Don't worry. Yes, Aditya, you stick around. Okay. Yes, Aditya, tell me.
Okay. Yes, sir. So my question was that the case which I took up, Jai Lakshmi versus Jai Lakshmi Saltworks versus State of Gujarat, that was also a case of negligence only on behalf of the state. In that, Justice B.J. Diwan held that the limitation period started from the time that the tort was committed. Sir, I have the judgment open also. Should I?
Yeah. Go ahead.
Sir, just a second. So should I read that entire paragraph or just the...
No, tell me the context because I don't remember the case. It's been a while, as I told you.
Yeah.